Good afternoon, everyone. If I could get a nod from the online participants, if you can hear me and see us well. Yes, perfect. Thank you so much. And apologies for the delay with the technical setup. We weren't able to go live on YouTube, but what we'll do is I'll kindly ask my team to please share the Zoom link with our online audience and to admit incoming participants. So good afternoon, everyone. My name is Valeria Bobre, and I'm a legal and advocacy officer with Women's Initiatives for Gender Justice. It's a pleasure to welcome both our in-person and our online attendants to this hybrid forum. Our discussions today will take place in the context of a global consultation process on the crime of gender persecution, aiming to gather input from civil society of the prosecutor of the International Criminal Court. The crime of gender persecution, despite being recognized as a crime against humanity in the Rome Statute for over 2 decades, remains one of the most under-addressed. And it wasn't until recently with the Al-Hassan case that the ICC began pursuing charges of gender persecution. The outcome of that case, with an acquittal on the gender persecution charge, highlighted just how much work still needs to be done to clarify and solidify understanding of this crime. We've seen important progress with recent initiatives such as the UN Women Guide on Identifying Gender Persecution and the ICC policy on the crime of gender persecution. Yet developments in Afghanistan, Iran, Myanmar, Yemen, Nigeria, the Tigray, and the DRC underscore the stringent need for awareness raising towards robust legal frameworks to address systematic gender-based oppression. Our goal today is to build on existing initiatives by focusing on 4 key pillars: prevention, protection, survivor participation, and relief and recovery. And as each of our speakers presents, I invite them to situate their interventions within one or more of these pillars. And by doing so, we aim to identify concrete recommendations that can inform both the development of the gender persecution principles by the Office of the Prosecutor, but also strategies for actors who work in this field, including ourselves, to raise awareness and address gender persecution globally. We have a fantastic lineup of speakers, and we're very grateful to them for their time and insights. And we also hope to hear from all of you in person and online, whether through reflections or questions. And we've allocated time for discussion after the prepared interventions, but I'll also try to pause after 2-3 speakers to check if there are any topical questions as we go along. And now I'll hand over the floor to our first speaker, Mr. Michael Warren from the IDLO. But first, I would like to thank all of the IDLO team for their warm hosting today. Thank you.
Thanks, Valera. Good afternoon, everyone. It's a real pleasure to be here with you and to welcome you to IDLO's conference space. We are very glad to be able to host this event. I send regrets on behalf of our director, Fabrizio Goreglia, who unfortunately is very ill today, so ill that he was actually not able to join via a video link, which is really unfortunate. So I'm going to share his very brief statement and then leave you to your hybrid forum. This forum comes at a very timely and critical moment when the world is facing intersecting crises, conflicts, and human rights violations, which are deeply rooted in issues of justice. The rule of law can provide a framework to tackle these challenges and address the inequalities and impunity behind them. As the only intergovernmental organization exclusively dedicated to advancing the rule of law for peace and sustainable development, IDLO has committed to reducing the justice gap for women and girls as a key objective of its strategic plan, in particular, combating gender-based violence. Within this framework, we have dedicated programs on the ground in various countries, as well as policy and research interventions to build the justice sector capacity to respond to women's justice needs in cases of gender-based violence, as well as to strengthen the capacities of women and girls to seek justice and claim their rights. While working on gender equality and access to justice for women and girls in countries across the globe, we encounter many situations of conflict or political instability where women and girls become the target of violence, as highlighted in our recent report, Survivor-Centered Justice for Gender-Based Violence in Complex Situations. That report, published in partnership with the Global Women's Institute at George Washington University, assessed the justice chain at the national level of different case study countries and called for approaches that place survivors at the heart of all efforts, ensuring not only a more comprehensive and survivor-sensitive global response to gender-based crimes, but also building successful and holistic strategies for awareness raising, identifying ways to prevent these crimes, protect those at risk, and involve underrepresented voices in these discussions. And I'll note that hard copies of that report are available in the office if you're interested in picking one up. To conclude, I wish you all a very fruitful forum to contribute to the development of comprehensive and inclusive principles to address the accountability, prevention, and protection protection of gender-based persecution. Lara, back to you. Thank you.
Thank you. We will now hear a keynote presentation from Azada Raz Mohammad, legal advisor for the Strategic Litigation Project at the Atlantic Council, PhD candidate at the University of Melbourne, co-founder of the Hamdili campaign, and co-author of the recently launched Handbook on Universal Jurisdiction, holding the Taliban accountable for international crimes. And Azada, a special thank you to you because we know you are joining us at a very late hour. So thank you, and over to you.
Thank you very much, Valeria, for the kind introduction. Good afternoon, ladies and gentlemen. It's indeed a pleasure to be among you all today, and I'm extremely humbled today to have been interested with delivering the keynote presentation in this important forum discussing the developments of gender persecution principles in the presence of my esteemed co-panelists and our audience today, some of whose work I deeply admire and seek their mentorship and advice in my projects regularly. This is a particularly valid opportunity for me to speak about the ordeal of the women of Afghanistan under the Taliban control, a topic that is directly relevant to our discussion today. Taking into account the objectives of developing the principles on gender persecution, I wanted to focus my talk today on the importance of prevention in terms of accountability, protection, and survivor participation in the context of Afghanistan to make my points about the crucial role that these elements play. For the past 3 years, unfortunately, the Taliban has been governing Afghanistan through terror and intimidation. Dismantling Afghanistan's justice system, the Taliban has issued over 100 decrees and edicts on the status of women, systematically subjugating women and girls and members of the LGBTQIA+ communities, depriving them of their most fundamental rights and confiscating their autonomy. Through these decrees, the Taliban has banned women's right to education, right to work, freedom of speech, freedom of assembly, movement, and speech. In their latest decree that was released on the 24th of August 2024, the Taliban has ordered women to cover their faces and conceal their voices in public. And the Taliban regime has also severely restricted women's access to justice and healthcare. In response to the Taliban's draconian laws, the women of Afghanistan has protested on the streets of Kabul and major cities in Afghanistan, demanding their rights by risking their lives, not only their lives, but the lives of their loved ones as well. The Taliban's response has been violent, with civil resistance by women against these decrees met with beating, lashes, and use of pepper spray and arbitrary arrests, torture, and even death. The Taliban has continued their arbitrarily arresting and detaining women, torturing women simply for demanding their rights. Every week, I hear from my friends and relatives in Afghanistan about the public flogging of women, enforced disappearance, rape, abduction, and killing of women by the Taliban. However, these developments unfortunately hardly makes headlines in international media. I humbly urge you all to please read the Special Rapporteur on the Situation of Afghanistan's latest report, which was published in June of this year. The report contains details of the Taliban's atrocities on women and girls in Afghanistan and the intersectional vulnerabilities within the Taliban's gender-based persecution. Since the Taliban's return to power, we often wonder, should we have held the Taliban accountable for their gender-based persecution and gender apartheid in 2001? Would we have witnessed their return to power yet again and continue their atrocities with such impunity on the basis of gender? Afghanistan is currently going through more than 4 decades of conflict with devastating effect on the people of Afghanistan, particularly women and girls. During the 4 decades of conflict, we have at least 3 peace processes which aim to bring peace and stability to our country. However, all of these peace negotiations resulted in more conflict and instability for Afghanistan, because in all of these three processes, one crucial element was missing: meaningful engagement with victim survivor groups, most importantly, the women of Afghanistan. We were repeatedly sidelined for political reasons, and our demand for accountability for the Taliban's gender-based persecution was ignored. Having experienced Taliban's brutal atrocities on the basis of gender in the late 1990s, the women and the people of Afghanistan raised their voices and concerns about the Doha peace processes, which was taking place between 2019 and 2021. We knew that the Taliban's ideology, and we knew that their system of governance is based on dehumanization and systematic oppression of women. Yet again, the international community ignored our concern and demand for accountability. Today, more than 3 years of the Taliban institutionalized oppression of women, and 30 years since the women of Afghanistan calling for accountability for Taliban's gender-based persecution. The international community has finally taken a substantial step in holding the Taliban accountable under the Convention on Elimination of All Forms of Discrimination Against Women. We welcome this development, and we are following the case eagerly. However, in order to dismantle Taliban's institutionalized system of gender oppression, as the Special Rapporteur on the situation of Afghanistan says, we need an all-accountability tool approach. In addition to the case under CEDAW, we believe that there are at least 3 available venues for accountability. First, in the absence of a domestic justice system, currently under the Taliban, we hope that the International Criminal Court will announce a progress on their ongoing investigation in the situation of Afghanistan, and we are very much hopeful that this case will have a major focus on gender persecution. The next available accountability mechanisms that we could refer could be under the principles of universal jurisdiction, which provides any third country may have an option or sometimes an obligation to prosecute perpetrators of international crimes who are based within their territory of that state. Unfortunately, we have seen that senior members of the Taliban are traveling to European capitals due to political consideration. The states have been reluctant to register a case against them, which is in contradiction to their obligation under the international conventions and also their national laws. Thirdly, we believe that the codification of gender apartheid in the draft convention on the crimes against humanity will provide us with the legal and policy frameworks to dismantle the Taliban's institutionalized system of gender-based oppression. The Taliban's institutionalized regime of systematic gender-based subjugation requires new legal tool. Since the mid-1990s, when the Taliban was in power for the first time, the women of Afghanistan has been referring to their situation under, or their experiences under the Taliban control as gender apartheid and calling for its discriminalization. We believe that the proposed crime of gender apartheid would complement and reinforce the existing crimes under the crimes against humanity of gender persecution by covering a distinct scope of the acts, an intent that further captures the nature of the crime committed in situations like Afghanistan and the Taliban-controlled Afghanistan. In all of these processes, a meaningful engagement with victim survivor groups and the women of Afghanistan is instrumental. I wanted to conclude my remarks today with emphasizing that the Taliban is basing their oppression on women and girls on a strict interpretation of Sharia law and Afghanistan's cultural heritage. This is far from reality. In fact, most of the Taliban's oppression of women are in direct contradiction with principles of Sharia law. And the same goes with the culture of the people of Afghanistan. They have formed actually their ideology on systematic subjugation of women. And in order to maintain that, they have to go through a system of gender apartheid and gender-based discrimination and subjugation. Thank you very much.
Thank you, Azada. You've really set the scene quite comprehensively for us in terms of gender persecution in the context of Afghanistan. And I will pause for a second because Azada might need to leave a bit earlier. So if there are any questions to her, please let us know in the chat or in the room in the next minutes. And in the meantime, our next speaker is Ana Martin, independent scholar and associate professor at Universidad Internacional de La Rioja, and she will present on the inherent intersectional nature of the crime of gender persecution. And we also have a presentation, which I will try to share. Please bear with me. Anna, please go ahead. Thank you.
Thanks, Valeria. Thank you very much to everyone. It is a real pleasure to be here with you today. I would like to comment on 4 main points on why gender persecution is an inherently intersectional crime. I will first comment on the concept of intersectionality, then the reasons why gender persecution is inherently intersectional. Then I will comment on key features of an intersectional analysis, and then how this intersectional analysis, this insight can guide or help international criminal law to interpret the crime of gender persecution.
Do you want to listen?
I have a problem with the slides. And I cannot.
I will try to move to the next slide if you let me know. Can you see the next slide now? Perfect, thank you.
So next slide, please. It's the one that says intersectionality.
Yes, unfortunately, we have a problem. I see it.
No
also,
problem.
it's blocked on my. Just give us 1 second.
Thanks, Valeria. So the concept of intersectionality has been crafted by feminist legal scholars whose work has then influenced international human rights law, in particular the Committee on the Elimination of All Forms of Discrimination Against Women, as well as regional courts, in particular the Inter-American Court of Human Rights. This work is also now trickling in international criminal law, in particular international prosecutorial strategies, such as that of the International Impartial Independent Mechanism for Syria, as well as the Office of the Prosecutor of the International Criminal Court. Through these works, we can glean an understanding of what intersectionality is, referring to compounded grounds of discrimination, and as a result of this compounded discrimination, a harm which is specific and of an aggravated nature. Actually, if we look into the policy on gender-based crimes of 2023 of the Office of the Prosecutor of the International Criminal Court, we can see that in enshrining the intersectional perspective, it adopts a similar understanding of intersectionality, noting that an intersectional perspective refers to understanding the differences in status, power, roles between persons as a result of political hierarchies and inequalities on intersecting grounds, such as race, ethnicity, socioeconomic status, religion, age, etc. And it is important to consider how these intersecting factors are in relation to the structural drivers of violence and impact people's vulnerabilities. In this way, it will be easier, or this will give us an insight into the meaning of the crimes and how victims experience these crimes. Moreover, the gender-based crime policy of the ICC prosecutor relates intersectionality with gravity. According to the policy, the gravity of gender-based crimes is determined by a myriad of factors such as age, gender, sex, culture, religion, and ultimately, as with other crimes, understanding gender-based crimes requires an intersectional approach. Indeed, we can consider that in all international crimes can be approached through an intersectional perspective, that intersectional discrimination in a way can underpin to a lesser or greater extent all international crimes. For instance, if we look into the recruitment of child soldiers, it is necessary to consider at both age and the gender of girls and boys to understand why they are targeted in a particular manner and the particular harms that they experience. Or if we take, for instance, sexual torture in detention, we have to consider not only the identity on ethnic, political, or religious grounds of the targeted group, but also the particular gender of men and women to understand why they experience sexual torture in a particular manner. The reason is that all persons have multiple identities, and identities are social constructions, therefore always in relation, exposed to the influence of other identities, including gender. All individuals have gender identities, and gender is a social construction that is interlinked with other identities. After considering what intersectionality is compounded grounds of discrimination resulting in aggravated harms and very specific harms, let's consider what reasons in particular would make of the crime of gender persecution a particularly intersecting crime. And next slide, please. Thank you. I would like to give 3 reasons why gender persecution is a particularly intersectional crime. First is the concept of gender as such, which is inherently intersectional. Another reason is the many overlaps between the crime of gender persecution and the meaning of intersectionality. And a third reason is the many references that we can glean through the elements of the crime of gender persecution into human rights law, which has developed an intersectional approach to discrimination, and in particular to gender discrimination. So gender first. Gender is a social construct. The Rome Statute defines it as the 2 sexes, male and female, within the context of society. The gender-based crime policy of the ICC prosecutor endorses and develops this understanding of gender as a social construct, noting that social constructs defining maleness and femaleness include roles, behaviors, activities, attributes. As a social construct, gender varies from society to society and evolves over time. The important question is then, what does gender as a social construction mean? How do we interpret it? One of the interpretations is that indeed gender is an intersectional category as such. This means that gender as a social construct is necessarily in relation to, interlinked with other identities, other situations that compound discrimination, that give it a meaning, a specific meaning in a particular context. If we consider the works of feminist legal scholars, as well as the Office of Prosecutorial Strategies, we can glean as well and actually appreciate this understanding of gender as inherently intersectional. So one of the characteristics of gender is its intersectional nature. For instance, in their work, Rosenthal, Osterveld, and Sakoto on what is gender, these authors note that gender is a socially constructed phenomenon that defines and enforces unequal power dynamics between females and males and operates intersectionally with other identities such as race, age, socioeconomic status, etc. In this way, it affects all aspects of society and societal structures. Therefore, according to these authors, gender operates intersectionally, and this characteristic affects to all aspects of society. The gender-based crime policy of the ICC prosecutor also adopts a same approach. Gender is inherently intersectional. It, according to paragraph 23 of the policy, a gender-competent analysis is part of the systematic intersectional analytical process that asks different questions about the crime in light of relevant intersecting factors such as gender, age, nationality, and ethnicity. Accordingly, a first reason why gender persecution should be considered an inherently intersectional crime is the nature of gender, which is as such an intersectional category or concept. A second reason why gender persecution is an inherently intersectional crime is the many overlaps between the elements of this crime and the concept of intersectionality, in particular elements 2 and 3. If we look into element 2, identity or group identity, the perpetrator targeted such person or persons by reason of the identity of a group or collectivity, or targeted the group or collectivity as such. And the third element, discrimination, discriminatory intent. Such targeting was based on political, racial, gender, or other grounds that are universally recognized as impermissible. Both elements, discrimination and based on identity, are the main aspects of discrimination. The only thing is that from an intersectional perspective, discrimination and group identity are often compounded, but discrimination based on identity in a compounded manner is what intersectionality is about. A third reason that makes gender persecution an inherently intersectional crime is the fact that also, if we consider the elements of the crime of persecution, there are many references to human rights law. And human rights law has developed an intersectional approach to gender discrimination. For instance, element 1 of the crime, the severe deprivation of fundamental rights, is a reference here to internationally recognized human rights. If we consider elements 2 and 3 that we have just noted, group identity and discrimination, these are also categories that are commonplace, that are the epicenter, the axis of human rights law. Therefore, these categories of the crime, the deprivation of fundamental rights, group identity, discrimination, are shared between gender persecution and human rights law. But moreover, if we interpret this crime through the lens of Article 21.3 of the Rome Statute, that requires interpreting the crime in consistency with human rights law and without discrimination, we see that there are compelling reasons to refer to the interpretation of gender persecution through the eyes of human rights law that has so much in common with this crime. Also, if we consider the views of legal scholars like Gregory Mausek or Priya Gopalan, they also support that Article 21.3 of the Rome Statute is a solid basis to incorporate an intersectional perspective into the Rome Statute. So let's look into what international human rights law says about the interpretation of gender discrimination and intersectionality. Please, next slide, please. The CEDAW committee has entrenched an interpretation of gender discrimination that is intersectional and that suits the interpretation of gender persecution under the Rome Statute. This interpretation has been in particular established by the CEDAW Committee's General Recommendation 28 of 2010 on the core obligations of states parties, but it has been systematically endorsed, this intersectional perspective of gender, in subsequent general recommendations. Moreover, it is important to consider that according to the CEDAW Committee, gender as an intersectional category is also applicable in situations of armed conflict. Moreover, the principle, the prohibition of non-discrimination, including on gender, is a norm, non-derogable norm of jus cogens, therefore applicable in armed conflict, where gender persecution often takes place and applicable in any event to international criminal law. So let's consider what the CEDAW's General Recommendation 28 says about gender discrimination in relation to intersectionality, and I quote, gender is inextricably linked with other factors that affect women, such as race, ethnicity, religion or belief, health status, age, class, caste, and sexual orientation and gender identity. Discrimination on the basis of sex or gender may affect women belonging to such groups to a different degree or in different ways to men. States parties must legally recognize such intersecting forms of discrimination and their compounded negative impact on the women concerned, and they must also prohibit them, they need to adopt and pursue policies and programs designed to eliminate such occurrences. Accordingly, if we consider this excerpt from the CEDAW committee, we can glean 4 traits of a gender-based intersectional analysis. One trait is that gender is inextricably linked with other factors. In other words, gender is intersectional. Another trait of a rights-based gender intersectional analysis is that it affects in different ways of degrees and degrees. In other words, the harms of gender intersectional discrimination are unique, are very specific as a result of compounded discrimination. Another trait of this analysis is that it has compounded negative effects. In other words, aggravated effects, the aggravated nature of the harms. And another trait is there is a duty of states parties to recognize and eliminate such occurrences. Therefore, there are obligations for states parties. According to the CEDAW's General Recommendation 28, dealing with gender and intersectionality, therefore, the CEDAW Committee sets out a gender intersectional analysis or several traits that regard to the causes and consequences of gender discrimination and the duties for states parties. Therefore, let's consider how this guidance from the CEDAW Committee, considering gender as an intersectional concept as such, can guide the interpretation of gender persecution as an inherently intersectional crime. And last slide, please. So let's consider the different traits of a rights-based gender intersectional analysis and think of how this can guide international criminal law interpreting gender persecution. If we consider a first trait of gender as an gender intersectional analysis, gender is inextricably linked with other factors. We could think that international criminal law may well adopt per default, a gender intersectional approach when interpreting gender persecution. And from this perspective, consider how the specific harms of victims are related to the dynamics of intersectional discrimination in the context where it takes place, and to charge gender on intersecting grounds when appropriate, as the Office of the Prosecutor is already doing. If we consider a second trait of a rights-based gender intersectional analysis, it affects in different ways and degrees. International criminal law, when interpreting gender persecution, could elicit the evidence of victims of these crimes from the perspective of intersectional discrimination, and note how the harms that they experience are multifaceted, how they are gendered in different ways, how they affect the different spheres of their personality, not only physical, but also emotional, family, socioeconomic. And of course, to consider how these very specific harms are linked to violations of fundamental rights. And with this insight of the specific harms of intersectional discrimination, inform reparations that are important, that have the power to be transformative because they are linked to the root causes of violence. If we consider another trait of a rights-based gender intersectional analysis, the aggravated nature of the harms, international criminal law may consider well how, due to the gravity of compounded discrimination, factors like victim vulnerability or the impact of the crime are affected, are more severe, and how this insight can inform the prosecutorial case selection or the gravity assessment of the crimes during sentencing. And finally, if we consider another trait of a gender intersectional analysis under human rights law, a duty to recognize and eliminate intersectional discrimination, how could, especially from the light of Article 21.3 of the Rome Statute, states parties comply with human rights law and therefore recognize and eliminate intersectional discrimination, where there is potential to do this in different ways? For instance, the judicial narrative could recognize the existence of intersectional discrimination. Intersectional discrimination could and should as well inform sentencing and reparations. And we could also think of the Assembly of States Parties recognizing the existence of intersectional discrimination as a problem for access to justice. So this is what I wanted to share with you about gender persecution as an inherently intersectional crime, due to the nature of gender as such, as an intersectional concept, and to the many references to human rights law that has developed a gender intersectional approach to interpret gender discrimination. And in particular, this importance of human rights law gains weight when considered in the light of Article 21.3 of the Rome Statute. Thank you very much.
Many thanks, Anna, for this very thorough legal analysis. I'm going to stop sharing your presentation, if I can. Yes, perfect. And I see no questions in the chat. Are there any questions in the room at this moment? No, none noted. And this is especially for Azada, who is considering leaving, but thank you again to both our speakers so far. And we will now hear from Evelina Ochab, Senior Program Lawyer at the International Bar Association Human Rights Institute, on the efforts to codify the crime of gender apartheid, how this crime differs from gender persecution, and why both crimes might be needed for a more nuanced and thorough legal response. Evelina, to you. Thank you.
Thank you very much. And thank you very much for putting together this roundtable, this conference, and for ensuring that we continue those important conversations about the issue of gender persecution, but also gender apartheid. And I wanted to, first of all, recognize the important work done, especially in the US. And I know that we have with us here Akila, I believe online, but also Sareta and others have been doing incredible work with Afghan and Iranian women to codify gender apartheid, and especially the End Gender Apartheid campaign, which has been key, of course, in starting the conversations about the need to codify gender apartheid. And indeed, after this campaign was launched, it received a lot of attention, and also attention by British politicians. And that's where my work comes into play. I have been working with British politicians for several years now. And as the campaign was launched by Afghan and Iranian women, there were also questions how British politicians and then British government should engage and should respond to the campaign. And at the time, we decided that it will be key to bring Afghan women, Iranian women to the UK Parliament and ensure that they can also speak to British politicians and share their stories, tell why it is important to engage on the topic and codify gender apartheid. And we launched an inquiry into the issue. And the inquiry followed the approach taken by the End Gender Apartheid campaign, focusing on the situation of Afghan and Iranian women, but looking at the situation separately, and then, of course, looking into the legal arguments, why we need to codify gender apartheid and how this could be done on the international level, but also on the domestic level in the UK. And this inquiry took place in the British Parliament earlier this year, heard from several Afghan and Iranian women, from several experts. We had incredible experts who have been dealing also with the apartheid in South Africa, including Justice Goldstone, but also Patricia Andrews and others who shared, of course, the incredible expertise and contributed to some of the arguments as they were being developed. We also had with us Professor Karima Ben-Noon, who also published a lot, not only about the recent gender apartheid as perpetrated by the second Taliban regime, but also by the first Taliban regime. And as we were looking into, of course, the situation of Afghan women, that was the comparison between the first and second regime was very, very powerful. And we had several Afghan women who came to the parliament who were evacuated by the UK government, who came to share some of their stories and their experiences from the first Taliban regime, and then, of course, sharing information about some of the freedoms that they had during the Afghan Republic. And then, of course, everything what happened since the Taliban took over Afghanistan. And as we were looking at the issue of gender persecution, gender apartheid, and of course looking at the Rome Statute, which provides the definition for gender persecution in crimes against humanity. Of course, it was very clear that the situation of women in Afghanistan and the nature of the institutionalized systematic oppression, discrimination, segregation cannot be effectively presented as gender persecution. Gender persecution differs significantly from what women in Afghanistan experience. And while, of course, it is important to pursue gender persecution and pursue accountability for gender persecution, it is not an effective response to the institutionalized nature of the situation faced by women. The same way as the racial persecution would not have been an adequate response to the treatment of Black people in South Africa. And I think this comparison between the treatment of Black people in South Africa and women in Afghanistan came very clearly during the inquiry from several experts that we've been hearing from, including, of course, the two experts from South Africa that I mentioned to you, who also testify and advise the inquiry along the way. And as a result of the inquiry, and the inquiry published a report that was signed by several parliamentarians. There were several recommendations, including what should happen and what the UK should be doing, including supporting, of course, the big campaign. And again, Akila, who's joining us online, has been leading some of those efforts together with Metro Mehran and others. There is this big campaign to codify gender apartheid within the Convention of Crimes Against Humanity, which is, of course, a very important step to ensure that there's an obligation to not only punish the crime, but also to prevent the crime. And something that's, that, for example, right now, of course, the only duties to prevent and punish in the law that we have, it's only in relation to genocide. And if or when the convention proceeds, of course, such obligations will exist also in relation to the crimes against humanity. And ideally, of course, if the crime of gender apartheid was to be included there, this would add yet another tool in the toolbox, as it was also mentioned earlier by Azadeh. In addition to this, we've been looking also into amending the Rome Statute and ensuring that gender apartheid, the definition of gender apartheid, is also included in the Rome Statute. And this, of course, to enabling us also to be able to pursue the crime of gender apartheid here in The Hague by the International Criminal Court. And indeed, in the newest IBA International Criminal Court document, which talks about strengthening the International Criminal Court and the Rome Statute system, a guide for state parties, the recommendation to codify gender apartheid is included. And Kate, who is Kate Orlowski from our IBA Hague office, is here with us, and she will be able to share the copy of the document if of course of interest. It includes also other recommendations, so it's a quite heavy document. But also it includes recommendation in terms of expanding the definition of gender, which is something that those conversations have been happening for a while now, but again, we are still far from actually ensuring that it becomes reality. And also amendment to the Rome Statute and the conversations around it have to happen. And it's a long process, as we know. And if we, for example, even observe what's been happening with the recommendation to codify ecocide, it's been there for a while. Now we are moving closer to this amendment actually become a reality. But ultimately, of course, it takes a very long time. And the more of such conversations on the amendment to the Rome Statute we have, of course, that increases the chances of the gender apartheid being also codified in the Rome Statute. So those conversations have to happen, and I hope that we'll also have specific conversations about which in the months to come, focusing on the need to amend the Rome Statute. And the other recommendation that I would like to mention here as well, that we were having conversations in the UK, was to also codify gender apartheid in the UK law. And at the time, of course, when we published the gender apartheid inquiry, that was still when we had the Tory government that did not want to engage on the issue of gender apartheid. And it was shortly before the election. Now we have a new government, we have over 330 new parliamentarians, which provides new opportunities, but at the same time, it takes some time for them to also identify where exactly they stand or where the party stands on the topic. We definitely have better engagement on international crimes with the new government, but again, it takes a while. However, even this week, tomorrow, we have a roundtable with Afghan women in the UK Parliament. It is with Afghan women who are based in the UK who can come to Parliament and tell or share their stories, especially engaging the new politicians who join us very recently. And on Thursday, we have a meeting with the minister responsible for the Middle East, North Africa, Afghanistan, and Pakistan. A massive portfolio, but nonetheless, a person who is very much interested in the situation of Afghan women. Recently also met a number of Afghan women to talk about the situation and see how the UK could potentially engage and the initiatives that the UK could support on the international level, whether with the Convention on Crimes Against Humanity, whether any future amendment to the Rome Statute, or anything else. And in relation to the domestic law, there was a bill that was meant to be tabled by one of MPs, members of the House of Commons. That bill, Codifying Gender Apartheid, was tabled, but unfortunately it did not come up in the ballot. In relation to private members' bill, we have a ballot that all parliamentarians put their bills into a hat, so to say, and then 20 bills will be picked up. And unfortunately, the gender apartheid bill was not picked in that ballot. But whenever there's a possibility, for example, if there is a international criminal some kind of bill, domestic bill, will be able to table amendments that could potentially codify gender apartheid, and then of course see whether it has enough support or trying to engage other politicians to get the support that is needed for this law to become again reality. And just wanted to mention a few other things from the inquiry, but also other inquiries. And of course, we talked a lot about intersectionality. And this is something that was identified in the inquiry as something that we need to look into more. The gender apartheid inquiry in the UK Parliament was a very short inquiry because we wanted to hear from as many Afghan Iranian women as possible, from experts, put it together and identify recommendations for the government and push the government to do more, even before the election. But ultimately, of course, there were several aspects that we identified that require further attention, and intersectionality was one of them. And we identify also, for example, looking into the situation of the Hazara women and them being targeted not only because of their gender, but also because of their ethnicity or because of their religion, and ensure that we have more of these conversations. And one of Afghan women who is coming tomorrow to Parliament will be covering specifically this issue. We had another inquiry at the beginning of the Taliban regime, or just after the Taliban took over, and that was on the Hazara situation. Again, it looked into the situation of the Hazara, but then specifically the situation of women within everything what the Hazara community has been experiencing. But it did not go far enough, and that's the reason we also want to look into the situation yet again. And this is also important as we all know, the Office of the Prosecutor is looking into the situation of women, specifically women and girls in Afghanistan, but we also had some meetings to discuss the situation of the issue of the intersectionality in the situation of Hazara women. So, of course, you ask also a question, or you mentioned that we need to look into various aspects of gender persecution and look into, for example, how to engage with victims, survivors, and communities. And there's a lot that we can do, for example, to ensure that victim survivors are connected with the Office of the Prosecutor. Or if we know organizations that are collecting the data, also they send it to the Office of the Prosecutor, or we encourage others who have the relevant expertise to engage the Office of the Prosecutor or send Article 15 communications, because ultimately the more information goes to the Office of the Prosecutor, there'll be more pressure and more likely that those issues will be looked at. And this is something that we are trying to encourage various organizations, especially those who are based in the UK, where we can actually, of course, meet with them and support them in those efforts. And we are also working on Article 15 communications to the Office of the Prosecutor. And few very brief comments because I know that I don't have much time left. I can share also the gender apartheid inquiry, which contains a lot of information and a lot of the testimonies that we collected, where we're able to share them, and also very importantly, we are using the same definition of gender apartheid as proposed by the End Gender Apartheid campaign by Richard Bennett, and as it's been used in recent discussions on the topic, and very brief comments because we all started talking about the issue of intersectionality, and just something that I think requires further attention is the Al Hassan case, and especially the dissenting opinion of Judge Kimberly Prost, because of course she expresses the satisfaction how the issue of intersectionality has been dealt with. And of course, just looking at other cases, we do not have enough conversations and discussions or scholarship on the issue of intersectionality from recent cases. And of course, one of the biggest cases where we could talk about the issue of intersectionality, the Daesh atrocities against Yazidi women and girls, it will never come before the International Criminal Court because of the limitations, as we know. And unfortunately, in this case, there have been several domestic cases where, for example, the genocide against the Yazidis have been raised, but unfortunately didn't go far enough to engage in those important conversations about intersectionality. When the case of Afghan women will come before the ICC, I believe, then of course this provides us with a great opportunity to engage on the issue. But again, those arguments have to be developed, including by the lawyers who are representing victim survivors. It could be also included in the submissions and expand upon the Article 15 submissions from civil society organizations, experts, and so on. But it cannot be ignored because, of course, I think there is a growing understanding that women, for example, in Afghanistan or in Iraq or other places, are persecuted not only because of their gender, but also because of their ethnicity, religion, and so on. And this double and triple vulnerability has an effect on, of course, the situation and has to be addressed. It is not enough to address only one aspect of the atrocities. All aspects have to be addressed. And the same goes to the issue of gender apartheid that, of course, right now we cannot address before the ICC, but we can address gender persecution. But addressing gender persecution and pursuing accountability for gender persecution before the ICC will not address the whole scale and the nature, the true nature of what women are facing in Afghanistan. And only by codifying gender apartheid and then pursuing, of course, accountability for it, we'll be able to come closer to it. As Karim Khan sometimes says, that in such cases, we are not going to get justice, but we will get accountability. And I think we need to use all those avenues that are available or that we can create in the future. So I will stop here, but I will just mention once again that some of the recommendations, and including on codifying gender apartheid, are already included in this IBA document that of course will be shared with states, and there'll be another document, I believe, that will go to states before the ASP so that they can also hear more about some of the recommendations that are needed to ensure justice and accountability for women in Afghanistan and other places. So I will stop here.
Thank you so much, and we will make sure to also include this in a list of resources that we will be sharing with participants after the meeting. So we will now delve even deeper in the particularities of the crime against humanity of gender persecution with an intervention from Valérie Gabar, co-director at Uprights, who will share some findings and lessons learned from the work of Uprights on two comprehensive publications on Afghanistan and Iran, respectively. Valerie, over to you. Thank you.
Thank you, and thanks for inviting me today to present some of the work that Uprights have been doing over the last 2 years on gender persecution in the context of Afghanistan and Iran. So given the limited time available, I will not bother you with all the legal analysis of the submission we've been doing on gender persecution in these two contexts, but maybe I will focus on maybe stepping back a little bit and explaining why I think the crimes against humanity of gender persecution is an essential tool that's available, and that is definitions is quite flexible and broad, at least if we read it in the way the policy paper of the prosecutor is reading it. It would allow for combating systemic and deeply rooted discrimination against women and girls in both contexts. So I'm never going to do as good as Ada as presenting the situation in Afghanistan, but just to maybe say a word on it. In Afghanistan, the situation of women and girls since the Taliban took over the country in August 2021 keep deteriorating by the day. I don't think there's any situation in the world today that's so appealing for women and girls, and they have literally been erased from public arena and oppressed in every single aspect of their life. So in addition to strict restriction on dressing and moving freely, they are banned from receiving education and from a wide range of professions. The discrimination of this restriction are unequivocal in my opinion, and resistance against this policy has been met with intimidation, persecution, and violence by the Taliban de facto authorities, as it was powerfully described earlier. In Iran, the violent repression on the peaceful protests that followed the death of Miss Amini in September 2022 led to the killings or the injury of civilians, men, women, girls, boys, and LGBTQI+ individuals as a result of the excessive use of force by the Iranian security forces. Thousands of individuals perceived as opposing the government policies, including in relation to restrictions imposed on women and girls, in particular compulsory dress codes, have been arrested and imprisoned by the Iranian authorities. In detention, protesters and persons detained in relation to the protests have been subjected to torture, inhuman conditions, and the information available also suggests a pattern of sexual violence, specifically targeting women and girls. All these violent acts in relation to the protests have been taken place in a context of pre-existing discriminatory legal framework in Iran against women, girls, and LGBTQI+ individuals, and a strengthening of this restriction, notably by the more restrictive approach to compulsory veiling that actually led to the protest. So the only purpose of talking a little bit about this situation was a little bit to set up the scene, because I think while the situation in which women and girls are discriminatorily placed in both Iran and Afghanistan is very different, as we see from these short descriptions. In our opinion, both cases amount to the crimes against humanity of gender persecution. So as part of Upright's mandate to create partnership to advance international law and accountability for international crimes, we have been working together with partner organizations to promote a better understanding of the situation of women and girls in Afghanistan and Iran. And in fact, to explain how the crimes against humanity of gender persecutions could and should be used as a powerful legal tool to address violations and crimes committed against women and girls in both contexts. So in partnership with Amnesty International and the International Commission of Jurists, we produced a report in March 2023 entitled The Taliban's War on Women. And in fact, it was relying on the human rights documentations conducted by Amnesty International in the context of Afghanistan. And the idea was to use the documentation already done to provide a compelling legal analysis showing that the situation of women and girls amount to crimes against humanity, and in particular to gender persecution as defined by Article 7.1 of the ICC statutes. The situation, as it was discussed already before, so I'm not going to get a lot into it, and I know there is some more presentation on the ICC, but the Office of the Afghanistan is going to be a very strong test case for gender persecution at the ICC, if they ever managed to get arrest warrants. But the Office of the Prosecutor have made clear that the situation of women and girls since 2021 is at the heart of their investigations in Afghanistan, and that they have made significant progress on it. So I think that is going to be very interesting to see, and it's going to be very strong test case for the ICC and for the notion of gender persecution at the court. In relation to Iran, together with human rights activists in Iran and with the support of local civil society organizations that I cannot name for security reasons, we also filed in December 2023 a submission to the independent and international fact-finding mission on the Islamic Republic of Iran. And the purpose of these submissions was to submit information available and also to provide some legal analysis to the fact-finding missions, trying to convince them to conclude that crimes against humanity of gender persecution, gender and political persecution have been taking place in Iran since at least 16 September 22 and the start of the Women's Life Freedom Movement. Such conclusion was ultimately reached by the fact-finding mission in their final reports. And then obviously, although Iran is not a party to the ICC and avenues for accountabilities maybe a bit more limited in terms of international crime at this point, there is still avenues to be explored, I believe. And that's maybe something we can also discuss in the discussion. Both situations illustrates, in our opinions, opportunity to light on crimes against humanity, where there are systemic and embedded discriminations against women and girls and LGBTQI plus individuals. As I said in introduction, gender persecution, as it's currently defined by the jurisprudence and interpreted by the ICC OTP policy paper, is, in our opinions, very favorable with looking for using these crimes to pursue accountability in Iran and Afghanistan. There is two aspects I'd like to emphasize maybe a little bit more without going into a lot of details. This is one is related, let's say, to the actus reus of the crimes and how gender persecutions, which criminalize severe and systematic deprivation of human rights of women and girls, is wide enough so that it can encompass both situations like Iran and Afghanistan. And then maybe I'll say the word on the discriminatory intent in the context of gender persecutions, focusing maybe this time a little bit more on Iran, where, in my opinion, the situation is a bit nuanced, and that relates more to the discussions on intersectionality that was mentioned by two of the participants. Now, intersectionality can be a very powerful tool also to address more nuanced situations. In relation to gender, to the severe or systematic deprivation of human rights of women and girls, the specificity of the underlying act of persecution as opposed to any other crimes, maybe, or not at least to that extent, and the crimes against humanity is that it...
Did you finish the whole bottle?
Yes, outside.
No, I mean, the one that I got.
Yeah.
The one that you opened?
Yeah.
It was also mentioned earlier of crimes against humanity or persecution. More importantly, acts of persecutions are not confined to facts that are otherwise underlying acts of crimes against humanity. And they may not even require the use of physical violence and the infringement of individual freedoms, such as the right to education, the denial of access to public services, denial of employment, or denial of the right to due process of law, or even the destruction of seizure of property, have been considered as persecutorial acts in the past. So in the context of Afghanistan and Iran, it allowed to encompass the systematic and embedded in society discrimination against women and girls, and more broadly, and also LGBTQI plus individuals. For instance, in Afghanistan, the discriminatory restriction that the Taliban impose on girls amount to serious violation of human rights, obviously guaranteed by numerous treaties. It's quite easy to show, including the International Convention on Civil and Political Rights, CEDAW, the International Convention on Economical, Social, and Cultural Rights. So if, for instance, we take the example of the right to education, it's clear that the Taliban's policies are on their face inconsistent with the right of education as reflected in those human rights treaty. And we can apply that to all these other decrees and rules that have been affecting the human rights of women in Afghanistan that were mentioned earlier. And in many cases, even a collection of the Taliban official legislation in this respect is probably a strong the repression of protest that also constitute other underlying acts of crimes against humanity, so like murder, torture, imprisonment, rape, and other form of sexual violence or inhuman acts. With the violation of the number of the rights of women and girls embedded in the Iranian legal framework, such as the violation of the rights of freedom of thoughts, religions, expressions, movement, the right to privacy, participation in public affairs, the right to freely pursue their economic, social, and cultural development that would constitute persecutorial act. So I guess here I'm just trying to show that even though the situations are very different in both contexts, the actus reus of gender persecutions allow to describe the various situations and embody not only the classical underlying acts of crimes against humanity, but also the much more complex everyday situation of women and girls in these two countries. Just to close on discriminations, I think in the context, obviously in the context of Afghanistan, the role of intersectionality can also be very, very important, but on its face, the targeting of women and girls because of their gender is not very controversial. All the severe violations stem from policy that explicitly identified women as a group to be targeted. The circumstances surrounding the acts of persecution indicate that the alleged perpetrator, as part of the Taliban leadership, acted with the specific intent to target Afghan women and girls on the basis of their gender. So I do believe that intersectionality would bring some nuance and allow to bring different situations to the picture. But I think the question of gender persecution, for instance, for the ICC can easily be shown in court. But in the context of Iran, the situation is slightly more nuanced, I believe, because first, in the context of Iran, the victims are not only, and even sometimes not even primarily women and girls in the context of the protest. And that doesn't mean that the crimes, that this is a problem in the context of the crimes of persecutions, because not what matter is not the group as such, because all the victims are not required to be members, sympathizers, or allies, or in any other way related to the targeted group. But what's really important, and that's explained very well in the OTP policy on gender persecution, is that the targeted group should be viewed broadly, including those who are not directly part of the group. And because what is relevant is not that the victim necessarily belongs to that group, but rather how the perpetrator perceives the victim in relation to the group and she's targeting them on that basis, which means you can be targeted on the basis of gender against women and girl, even though you are not a woman or a girl, for instance. So we can elaborate on that. Nevertheless, on the basis of the information that were available to us, and I have to acknowledge here that the documentation, the information available on the public domain have not necessarily been investigations that were targeted on documenting gender persecution. So sometimes it is maybe the need to have more documentation or information on it. But it's not always easy in the context of Iran to assess the discriminatory intent of the perpetrator, because there is a lot of intersection between political persecution and gender persecution in the context of Iran in general, but in the context of this protest in particular. So the beauty of intersectionality in this context is that while the existence of one discriminatory ground is sufficient, as the OTP said in its policy paper, a combination of more than one may equally form the basis of the discriminations. And obviously the ICC judgment in the Al-Hassan case, and even though it is a little bit confusing to say the least, at least in our opinion, is some kind of recognition that intersectionality should apply between various grounds, and that it's opening a way forward in that respect. And that's very, very important, as it was, I think, explained earlier also very well, is that it's, in my opinion, allowed to accurately reflect nuances in the facts that are under consideration in a situation like Iran. Obviously, I have only talked about political and gender, but obviously in the context of Iran, there is also potentially religious and some ethnic aspect as well that could be very reflected very well under gender persecution using intersectionality. So that's just done. So that's all I had to say on this. I just wanted to highlight those 2 points, and yes, more or less that's it. Yeah, so that's fine.
Thank you for this presentation and the comparison between the two contexts. And I'm happy to hear intersectionality as a common thread through our speakers. And the Al-Hassan case was mentioned again. And the trial judgment issued in the Al-Hassan case earlier this year convicts him for religious persecution, while he's acquitted for gender persecution and in fact of all other gender-based charges. So our next speaker, Sarita Ashraf, a barrister specializing in international criminal law, will help us shed more light into these findings and the challenges with which make charges of gender persecution difficult to successfully prosecute. So Sarita, I can see you and I will highlight you in a second. Over to you. Thank you.
Thank you. It's great to see everyone online and in the room, and sorry that I couldn't be there in person. I hope you're hearing me all right. So I've been given the brief today to discuss challenges in recognizing gender persecution. And as part of that, I will be discussing the Al-Hassan case, although I'm not going to go into detail on it. I hope we can do a little bit of that in the discussion, but also because I think the Al-Hassan case is probably ripe for appeal. And so I hope that on appeal, there will be a little bit more clarity in how all the crimes, including the crime of gender persecution, is tackled in the Al-Hassan, noting that the only point in which the judges managed to agree, all 3 judges managed to agree, was on the acquittal on charges of attacks against protected objects as a war crime. So we do have a very bumpy, I would say, judgment that is ripe for appeal. So on the topic of the challenges in recognizing gender persecution, it is something that is more of a question than a presentation, and I'm sure that there'll be a lot of views in the room. I wanted to emphasize a few things. The first is just to note how early days it is when it comes to the crime of gender persecution, and how early we still are in our understanding of it. There are only currently 3 cases in which it's been indicted at the ICC, and of course we have the Al-Hassan judgment coming out in late of June of this year, so only a few months ago. Often when we're speaking about gender persecution, we're speaking about it usually in a group of people who work a lot on other gender issues or specifically on gender persecution. There's a tremendous amount of recourse to a discussion of the OTP's policy on gender persecution. But I think it's always good to remember that this isn't, the policy is incredibly useful, incredibly insightful, has very strong understandings both of gender, of persecution, of intersectionality, but it still remains very much an internal policy of an office of the ICC and is not as yet a source of law. So the question is always going to be, how does gender persecution show up in the jurisprudence of the ICC, and how is that going to inform our understanding and the understanding of those who perhaps do not work at the coal face of gender? So I'm going to start off with one question, which I think underpins some of the challenges and maybe frame some of the challenges. And that is there a challenge with identifying gender persecution, or perhaps is there also a challenge of identifying gender persecution when it is committed against more marginalized, less visible individuals and groups? I say that because in the three cases that are being indicted for the ICC, in two of those cases that deal specifically with gender persecution against men and boys. And of course, we know, as everyone in this room will know, and I'm sure has said in various ways and in many proceedings, that gender does not only mean women and girls. However, it is quite noticeable that in some of the cases, notably the Sudan case, there was some question as to why crimes against women had not been indicted as a form of gender persecution. So I think that when we speak about challenges in identifying and recognizing gender persecution, we're not simply talking about the crime, we're also talking about differences of when we're better able to recognize a crime that's being committed when it's committed against those who hold more value or are perceived to hold more value in a particular society, and then where it's not being necessarily as indicted. That moves us on to the question of when it has been indicted against women and girls, as we can see in the Al Hassan case, that we didn't end up with a conviction for gender persecution, and that came down to the mathematics of the decision-making by the judges. However, what was very clear is that there was a real challenge around, first of all, identifying intersectionality, and I think it was Aline who mentioned the individual opinion of Judge Prost, and certainly the difference between Judge Prost's and understanding of intersectionality versus the other judges on there, and particularly the judge in the minority, Judge Okane. One of the questions around that is looking at how, when we're talking about intersectionality, that is understood. It was understood, for example, in the pretrial confirmation decision, but we see still the chamber struggling with an understanding of essentially binaries, that one will fit within one prism, whether it's religious persecution, and that will be subsumed. So there's not a general understanding of intersectionality. The other is the question of how gender competence is operating across the ICC. Again, I think in rooms such as this, and often in the conversations I have, we understand gender competence as being maybe more entrenched than it is. And I think one of the things that seems to be a challenge for that Al Hassan brought out was that how the thread of everyday misogyny, how the everyday subjugation, particularly of women and girls, is poorly understood, and the process by which that everyday misogyny, everyday subjugation metastasizes, if it finds the right environment, into a crime against humanity is really poorly understood. And it seemed to me, the underpinnings of some of what was in the Al Hassan judgment was this idea of when you can tolerate a level of harm, a level of discrimination, that tolerance very quickly results in the invisibility of harm. So I think that there's a very, very strong continuum between tolerating violence, normalization of violence, and this can be quiet violence as well as loud violence of harm, that you then don't necessarily then see it, even when it bursts into view in the form of a crime that should shock the conscience of humanity. The third thing that I think Al Hassan puts into question is how our understanding of gender persecution is evolving in the framework of international criminal law versus human rights law. Often our understanding of gender persecution for good reason has arisen out of human rights law, but it is going to develop further in international criminal law. And that's particularly when it comes to the connectivity requirement. which is the fourth requirement identified in that the Al-Hassan judgment discusses. Again, I think we're going to have to look at this question of how it connects to other crimes in the Rome Statute, whether there's going to be a broad interpretation as the majority suggests, or whether it's going to be more demanding necessarily than a human rights law approach would necessarily hope for. The fourth point that I wanted to raise when it comes to the challenges in recognizing gender persecution is the impact on survivors. When it comes, we talked a little bit about prevention, about survivor-centered justice. The history of international criminal law is very much a history of surfacing the experiences of those who have been marginalized, been rendered invisible, or been excluded sometimes with layers of visibility, of inclusion and exclusion, visibility and obscurity. But it's worth noting that at multiple stages in the history of the international criminal justice experiment, there has been a particular invisibilization of women and girls. That's also not to say that there aren't other groups which are maybe even more deeply rendered invisible, including, for example, the LGBTQI community. But it is notable in the history that women and girls are consistently treated as witnesses to atrocity and not victims and survivors of atrocity. And so what has happened in Al-Hassan follows actually a fairly consistent history in terms of the experience of women and girls of international justice. And if you go back all the way to the early days of the ICTR, when rape wasn't being charged, and when rape was charged, there were a tremendous number of acquittals in the early years of the ICTR. One survivor speaking to media said, "If the tribunal does not change its approach to give value to women, then it's not worth it for us to work with them." The Al-Hassan case, again, a trial judgment, highly, I think, appealable case, emphasizes that you can have a great policy from the prosecutor, you can have great training and great sensitivity on gender competence and intersectionality within the office of the prosecutor. You can run a good case. I'm sure that there will be critiques or however a case may be run, but unless that level of understanding or competency infiltrates the entire justice institution, you're always going to have a risk that survivors are going to put themselves forward and still be removed from the historical record that is created through the transcripts and through the trial processes of any tribunal. And it takes me to my final point. I'm mindful of the time, and I hope we'll have a bit of time for discussion. So I am moving quickly through. And my final point is on the importance of cumulative charging. The one thing that we know is progress on gender is extremely nonlinear. That we can trace through a jump forward, such as Akayesu, followed by an immediate failure to take advantage of avenues that have opened up. Such is the nature of trying to overturn a value of hierarchies, or values of exclusion inside institutions, which don't come down to any one person or one office. Cumulative charging assists with ensuring that we are using all the tools, that we are equipping ourselves with all the tools we need to move forward, while still pushing forward for more progress, more understanding, more training, and more action on crimes like gender apartheid. So yes, there are challenges in reckoning gender apartheid. I work too much in gender apartheid, gender persecution. There are tremendous challenges in recognizing gender persecution. Those challenges are not new. They are a reinvention of challenges we've seen on other crimes which disproportionately or are perceived to disproportionately affect women and girls. Where we have our strength is continuing to push forward, but part of that is also saying we cannot make a campaign simply of one crime. We need to utilize all the avenues that exist within the Rome Statute to ensure that while we're moving forward in advocacy, that the interests and the needs of survivors are also going to be met through ensuring a broad-based all tools approach. Thank you.
Many thanks, Rita. I think your points are great food for thought for participants who might be interested to monitor appeal efforts or maybe even be involved in them. And we'll move on to our next speaker. So an intention to bring charges of gender persecution against Afghanistan before another international court in The Hague, the ICJ, was recently announced by Australia, Canada, Germany, and the Netherlands. And our next speaker will help us explore the symbolic and didactic effect of such charges before international courts, and particularly in cases where the outcome or its implementation may present challenges or not fully meet the expectation of the victims. So I'll hand over to Jens Iverson, Assistant Professor at the Grotius Center for International Law. Over to you. Thank you.
Great. Thanks so much, Valeria. Thanks, Alix, for having me. Some fantastic presentations today, and I can't wait to get your research bundle and figure out what I can push onto my students. A lot of learning, and I'm hoping to get to the Q&A shortly to learn a bit more. I have questions. So I'm going to try to do three things to minimize the time I'm taking up. First, go into what Women's Initiatives asked me to approach, this didactic effects of recent developments at the ICC and ICJ, give my sort of bottom line answer, which is that actually, I think these didactic symbolic effects are good, even though your initial response, like from Sarita, like from Judge Prost, might be, oh, this is so frustrating. But there are some really strong didactic effects we can take from them if you take a long view, and then just to amplify what those developments are. I'm going to drop my discussion of prosecutorial discretion and how it feeds into all of that to make room for time. So the symbolic didactic effect of such charges, how to most appropriately respond when they don't materialize in a conviction, such as in Al Hassan, or when enforcement implementation is highly unlikely, such as the ICJ proceedings. That's my brief. I'm going to question the assumption in the last part of that at the end. So what are we talking about when we're talking about a didactic effect, right? I try to, you know, imagine in my mind if we could throw away deterrence, right? No deterrent effect, no incapacitation effect, even, you know, just deserts, and assume that what's going on in the courtroom has no effects on what people normally use to justify this whole project. Then one of the things we're left with is this idea that even if it doesn't scare anyone or stop any bad guys from doing anything further or even achieve justice, it's still really valuable to come up with new norms, to articulate them, to have them explained through criminal legal processes. So there's a scholar, Miriam Damashka, who really pushed this forward as the main reason to have international criminal law, not the sort of normal reasons we have for domestic criminal law. But with ICL, since there are so few prosecutions, such limited punishment, the rationale is really fundamentally different. And I think one classic example of that in the ICC's history is child soldiering, that there's some good reason to believe that by picking that particular crime and putting it forward, there was a real effect of making that norm, you know, adopted, not just in round tables, but in the field where it mattered. And so, you know, with that framing of the didactic effect, why am I saying that despite the frustration that you can hear in Judge Prost's dissent and maybe in this room with Hassan, and maybe the preemptive frustration that even if we get a good ICJ ruling, you know, which army is going to enforce it, you know, noting what all of the speakers have talked about where we are being in early days, there's a lot we can do with these developments, particularly if, as we all hope, we get a good appeals ruling and a good series of judgments from the ICJ. And I really have some hope for both of those, even though the ICJ isn't always where I would go for great human rights rulings. So, you know, I think what we want to get to in respect to gender persecution in particular is to, you know, take a survey of, you know, these situations we look at atrocities. My particular background is transitions out of armed conflict, but can happen in peace. And there's almost always some gender aspect, right? So for the OTP, you see this to some degree in their policy papers. The question, you know, it's not like the laundry list of normal crimes. For something like, you know, gender-based crimes, but gender persecution in particular, if they're not finding a differential gender effect in their initial gathering of data and preliminary examination and examination, it seems like, you know, some of the language that's mouthed in these policy papers of doing due diligence, what that should mean in practice is that it really should be double-checked, that it should be a surprise if you're not finding that effect. And if you're finding that effect, then it shouldn't be such a reach to find specific intent, right? To say it's probably not by accident. They probably did have some rationale here. It's not just random, right? And so that understanding of gender-based persecution specifically takes it from this really, you know, exceptional, rare case to saying, particularly with respect to women and girls, it should be the norm to be, there should be some sort of explanation of why it isn't charged in quite a number of these situations, rather than picking it out as a particular thing to be charged to make a specific didactic impact. I think it's really different than something like child soldiering, where, you know, child soldiering doesn't happen in the majority of situations, in the majority of wars, in the majority of atrocities. Whereas when you look at sort of, you know, gender persecution and you think about how it comes back, yes, there are particular histories and particular structures of dominance in each case. It's complex, there's intersectionality, but generally we can sort of say, this is almost a normal result of profound inequalities that might exist in ordinary times. And then in the context of atrocity, you can understand how gender persecution happens. It should change the way we approach these, in particular, the way the OTP approaches them and articulates their case. And then hopefully, with repetition, we do get some education of the judiciary, whether it's at the trial level at the ICC, but hopefully in a number of venues, could be in domestic venues using universal jurisdiction. I think that's a brilliant initiative that we've heard about today and elsewhere. So what is the didactic effect here when we're looking at Al Hassan in particular? I think we can sort of think of it on 3 levels, right? First level, well, there's no conviction. So you might say, well, so there's no didactic effect or even a negative didactic effect, right? To say, boy, even in this, what should be an easy case, we can't get a conviction. This is so frustrating. Maybe it denigrates the crime or denigrates our sense of hope and expectation. Second level of didactic effect, what could we take away? What could we use to sort of reify these norms? Is that we do establish the crime base here, and that's historic, right? Whether or not you get conviction for a particular individual, whether you establish beyond a reasonable doubt his particular criminal culpability, it's a big deal to show gender persecution is a real thing, not just on paper, but in judicial findings in international criminal law at the ICC. And then on sort of a third level, and again, I think you see this in the prosecution's notice of appeal, in judge process discussion, in our discussion today, some of the rationales put forward that are the reasons why we don't have a conviction are really infuriating, right? To say, well, there's Sharia, so we can winkle out that a mistake of law. That's somehow a justification rather than evidence of how this system of domination happens. That we don't need to have a specific finding of a threat of death or serious bodily harm, and then there's some sort of just general duress you can waive at the general context here. So it does give us our own didactic moment of realizing how far we still have to go to bring our community of lawyers along with us to get to justice in these particular cases. I haven't touched on the ICJ at all, so I'll just wave at it briefly and say, of course, enforcement happens in a complex nature in international law. Yes, the Security Council is unlikely to march in and create enforcement, but what do? We borrow findings, right? We have that coming into ICJ, we can have that coming out of ICJ. If we have these authoritative findings, it can influence our policies with trade, with aid, with reliefs of government funds, with further criminal prosecutions of those involved. It's not the end of the story. I still think there can be really helpful didactic effects, even though, yes, international law enforcement is an ongoing problem. So I'll stop there. I'm a little over time, but not too bad. And I'm really looking forward to the last speaker in the Q&A.
Thank you very much for this hopeful outlook on the situation. And our final speaker is Grace Akan, a survivor activist from Uganda, leader of the Women's Advocacy Network and member of SEMA, the global network of victims and survivors of wartime sexual violence. One of the 4 pillars I mentioned in the introduction is survivor participation. And Grace, we would be grateful for your thoughts on how we can ensure meaningful participation of survivors in justice and accountability processes, and what are the needs of survivors, which might be at risk of being neglected by actors involved in these efforts. Over to you.
Thank you very much for giving me this opportunity to share my views on meaningful participation of survivors. First, I think it's important to include survivors, to make survivors participate because of the following reasons. The first one is to ensure that the diverse needs and perspectives of all individuals are included in all that are represented and addressed in post-conflict settings. Secondly, the unique challenges that women and children face make it very, very important for their voices to be heard. For example, really very serious impacts of conflict like sexual violence, displacement, really put them in really a condition that make them, if you don't include them in any intervention, you will fail to get exactly what they need. And the intervention will not be successful because, like I normally say, it's like for a doctor to treat a patient, you need to get you need to diagnose the right disease in order to give the right medicine. And then to promote gender sensitivity approaches and justice and reconciliation. For example, if survivors are included, here we're talking about, it gives you that, it gives ownership to survivors to understand that whatever intervention is for them and it will address their needs, and then they feel it is theirs and they put all their efforts to ensure it is a success. This also amplifies voices of marginalized groups. As we all know, survivors are marginalized groups, and they rarely speak. In most cases, because of what they went through, they cannot give you everything they feel. And so if their voices are included, and then there is a deeper understanding of what survivors go through, and then the intervention is taken rightly. And then survivor inclusiveness also help to shape and promote ownership, like I said before, and sustainability of the intervention. Going to the needs of survivors, the first one is the survivors should be given a safe environment for them to be free enough to speak about what is needed. The second one is social support that should be given by their families, the community in which they believe, in which they stay. And even at a family level, maybe their spouses should give them the chance to speak, chance to be part of the interventions that is in their areas. Survivors need comprehensive and survivor-centered approach. For example, access to specialized services like medical care, psychosocial support, legal assistance, safe shelter to address their immediate needs. That should be survivor-centered. It should involve them, and it should be gender responsive. Survivors should actively be included in program related to humanitarian services, humanitarian responses, like peace negotiations, peace building processes. This will bring out, like I said before, it will bring out those unique challenges, unique ideas that help to form, that help to shape the interventions. The voices of survivors are invaluable in shaping policies and interventions that address the root causes of conflict, and also address the root and also promote gender inequality. It's important to involve survivors in planning, implementation, and monitoring of humanitarian responses. Like I mentioned before, if you know the need of survivors, you'll address it rightly. And that should not, like I mentioned, I think I'm still going back, I will say, if you know it right, you'll address it right. Because a survivor may not only need one thing, might not only need psychosocial, but might also need social acceptance, might also need economic support. So if you address two of those or one of those that has been rightly said by the survivor, it means you are giving you're addressing the right challenge, and so you'll cause change, you'll bring change, you'll change the life of such survivors. I think my third one, I think my third point, my third intervention will be on how to ensure that transitional justice, transitional and restorative justice processes are meaningfully including gender persecuted survivors. One is have a gender sensitive policy and framework to address the needs of survivors. The second one is actively involve survivors in designing, it's just the same like I said before, and implementing justice mechanisms to ensure that their voices are heard and their perspectives are taken into consideration. I think in dealing with this also, train and build capacities of judges and legal professionals in sensitizing them to the particular needs of survivors, so that when they are, for example, when they're in the court, they really understand the unique challenges, what the survivors are going through, so that they give the right judges. Create safe and supportive space for survivors to come forward to share what they go through or what they have experienced. And lastly, I think address the socio-economic factors, or like inequalities and unequal power dynamics, lack of economic opportunities for survivors, and harmful cultural norms that deter survivors to come forward, to be involved in humanitarian responses that will affect their healing and interventions that are for them. Thank you very much.
Thank you to you, Grace. Our discussions today tend to be quite legal, so I'm very grateful that you also mentioned that the needs of survivors are multifaceted, so we need to discuss a more holistic approach and response to these crimes. Thank you to all of our speakers for your engaging and insightful contributions. And as we move into the discussion, I invite everyone here, both in the room and online, to ask questions, but also to share your own experiences and suggestions from your work on gender persecution. And we can make this a space for learning from each other. So I will pause for a second to see if there are any questions. Yes, Alex, over to you.
Thank you very much. I feel like cheating a little bit since I too am with Women's Initiatives for Gender Justice. And I would like to also thank all the speakers and in particular Grace. Thank you so very much for sharing your insights. And earlier as well, Azada, who I hope is in bed now since she spoke to us around midnight. My question is to any of the speakers really, but perhaps I'm looking at Jens or at Evelina. It's more specifically about relief and recovery. It's one of the 4 pillars, as Valeria has indicated, is part of our efforts to shape, fold, if you will, gender persecution principles of around 4 pillars, and relief and recovery is one of them. We had very in-depth, amazing discussions and insights, but how do we marry that with gender persecution in ICL? Is there room there for relief and recovery? But any of the speakers, I would be very, very keen to hear from all of you. And Valérie, perhaps you too, but I won't put anyone on the spot. Thank you.
And maybe in the meantime, we'll gather one more question. Lorraine, please.
Thank you very much. And thank you to Women's Initiatives and the other organizers of this really interesting event. My name is Lorraine Smith-Van Lin. I'm the director of Talawa Justice for Women and cheating a bit a consultant also with Women's Initiative. I have a few questions. I'm going to throw them on the table because this is about discussion. One of them, I don't like to call it devil's advocate, but I want to throw something out, and it has to do with the discussion about gender apartheid and gender persecution. Now, to my left, I have the colleague here from Uprights saying that the gender persecution framework in the Rome Statute is effectively enough to address some of the issues we see in the Afghanistan and Iran context. On the other side, we have Evelina saying where there is the end gender apartheid campaign, fully agree with it. And the discussion here that the gender persecution provision is sufficient to cover some of the crimes that we're now seeing. Have you heard at all any sort of counter arguments raised around the possibility of fragmentation? For example, if you then now try to add gender apartheid to the range of Rome Statute crimes, and does it then come back to this idea that we already have a framework which covers, discrimination, sort of systemic approaches to gender crimes, to persecution, and are we trying now to add to the challenges by bringing gender apartheid within the framework of the Rome Statute? So I would be really interested in hearing both your takes on it, hearing a little bit more as to why you think, and maybe Jens, if you feel like jumping in there as well, why you think gender persecution is enough, and if you then think there is no need for adding gender apartheid to the mix, and if you think by adding gender apartheid, if it means that there could potentially be fragmentation, given what we're seeing as well with the judges and the kind of reluctance anyway to address gender persecution within the existing framework. Thank you.
If I may respond to it, mostly because I also have to leave at 5 o'clock to catch my train to London. I think something which, of course, this is a very important conversation, and something what you said was gender persecution covers some of what is happening in Afghanistan. And I think this is precisely the point. It covers some of what is happening, not all of it, not the whole extent of the institutionalized discrimination, marginalization and suppression of women's rights, this segregation. And so this is not covered. And I think a very important question that we need to ask ourselves as well, are we satisfied that gender persecution goes far enough or pursuing accountability for it? And we could see similar approach, for example, in relation to other crimes, even the development of a crime of genocide, when in the UK, the Prime Minister was saying that we are seeing atrocities that are happening, that they don't have a name, they don't have a definition, but we see them, and how do we engage with it? And the same conversation we should have in relation to the situation of especially women in Afghanistan right now, that we don't have the legal language right now to describe the whole extent, the nature of the atrocities. And I do believe, and it's also my personal belief, that we cannot stop there, because gender persecution, again, does not go far enough. And a lot is left out. And I think we need to do better. And especially if we take the victim survivor-centric approach, we need to hear the voices of Afghan women who are saying that you don't see the situation of, or you don't see the reality of Afghan women anywhere in the world. This is something that needs to be addressed. And also, of course, to punish the perpetrators, but also to thinking about the future, because it's not going to stop there. We know it. Impunity for this kind of atrocities will lead to further atrocities somewhere else in the world, something similar. And I think, especially as we work on violence against women and girls, atrocities against women and girls, we need to also engage with those important questions and realize that this is not enough to do justice for those women who are being subjected to those atrocities. But as it stands, gender persecution in the context of the International Criminal Court is the only option right now. So that's the reason we need to pursue it. There is, of course, option to engage with other elements of crimes against humanity, especially other crimes of similar nature and so on, where we could develop the argument of gender apartheid. And but as it stands, again, that's the only option. But I don't think that we should stop there, because we need to pursue other avenues as well.
Okay, maybe just to respond to also the question, because I didn't necessarily meant it as a way of opposing the two notion. I think I haven't worked at all in the area of gender apartheid, and all the cases I've been working on was on the basis of existing legislation. So that's on that from that standpoint that I'm talking about. And I think, as you mentioned at the beginning, even though the gender persecution have been in the Rome Statute since I've been here since the Rome Statute, I think my point here is that there is whatever happened with the gender persecution, with the gender apartheid campaign, I think there is a lot of room to do things now in terms of gender persecution, and that there is a lot to explore with that notions in terms of knowing how far we can push it and its limitations, because we've also seen that there may be limitations, and some of Sareta's points were very fair in terms of, like, yes, the policy paper of the OTP is really nice, but for now that's not jurisprudence, right? So is that going to be what the court is going to do? It's also questions. I guess my point here is that based on the two situations we worked on, we can see that there is a lot of potential to explore within gender persecution, and that needs to be pushed, and that should not also be forgotten within this discussion on gender apartheid. Something maybe that I have noticed, though, within those discussions is that the gender apartheid debate take a lot of space in the room sometimes, in the sense, not necessarily in a negative way, but it asks a lot of effort to try to push for those crimes. And I just trying to be the voice in the room, maybe that people don't forget that we can use gender persecution, because in my discussions sometime with Iranian or Afghan human rights defender, because they really want to push for the crimes of gender apartheid. If they are not lawyers, etc., they might miss the fact that actually you also have a legal tool you can use now. So I just don't want that to be forgotten within the whole debate.
We'll go to, we'll go to Jens and then Sarita and then, thank you.
I also want to hear what Sarita has to say. And there was a great comment from Professor Gray. Maybe trying to tie things together. I'm skeptical there will be a prosecution for gender apartheid in the next few decades at the ICC, and I'm fully in favor of amending the Rome Statute to do so, because I think, you know, what I tried to invoke, the didactic effect, the Rome Statute system, where other countries can amend their regimes, they can use universal jurisdiction, and maybe to tie it into Alex's question with relief and recovery, it is very meaningful if people start discussing situations, not just saying, yes, there's specific animus towards a gender group, but recognizing the inherently systemic effect that we're talking about. That's a real differentiator when you're talking about apartheid system. So you know, it's right to be skeptical that we'll have, you know, they're not going to be reparations awards from this. It's not going to be that kind of thing. It's going to be much more societal in general and systematic if there are going to be effects. But I really appreciate you stirring the pot, Lorraine. That was brilliant.
Sarita will be with you just in 1 second. Evelina wants to make another comment before she leaves. I assume.
I really will have to run because otherwise I'll be stuck in The Hague. But just wanted to mention as well, I also absolutely agree that we have some existing legal avenues for justice and accountability that we have to pursue. But at the same time, we should continue pursuing again, as Jens mentioned, codifying gender apartheid and ensuring that in the future there will be more legal avenues for justice and accountability, more tools in the toolbox. But also we've heard about the universal jurisdiction, how it could be used and so on. And indeed also, for example, as it works in the UK, the Rome Statute is introduced into the domestic system via the International Criminal Court Act from 2001 that does not define all the crimes, just incorporates them as they are in the Rome Statute. And if you change them in the Rome Statute, then of course, then we could potentially explore prosecutions under the principle of universal jurisdiction for gender apartheid, if it of course is codified. There are certain other limitations of that law that I'm not going to discuss here because we'd need another few hours. But again, I absolutely agree. And that's the reason, for example, there is a lot of movement also of civil society organizations working with the Office of the Prosecutor, submitting Article 15 communications and so on. So there is a lot happening, the CEDAW proceedings. So there are existing mechanisms that need to be used and they're being used. And we need to support victim survivors to engage with them all. But at the same time, the conversation on gender apartheid has to be happening. States need to support it, and we need to see movement with the Convention on Crimes Against Humanity, with the Rome Statute, with domestic legislation and so on. We cannot stop at one of them, because I think, again, women of Afghanistan and Iran deserve more from the international community. I will stop here and I will just run to catch my train.
Thank you very much. And over to you, Sarita.
Sure, I'll try and be quick. This is probably the issue or question that gets raised in at least every other discussion I have about gender apartheid. And I think it's an understandable question, but I also think just in terms of the framing of it, it's not very helpful because it creates this binary between gender apartheid and gender persecution, which truly does not exist. In fact, it would probably make more sense to say, well, why do you need gender apartheid and other inhumane acts? Since the crime of gender apartheid is the commission of another inhumane act with a specific intent in the context, with a specific wider context. So I reject this kind of binary that consistently gets put in place between gender apartheid and gender persecution. I have yet to meet anyone who works in gender apartheid that is not supportive of gender persecution. But I also think it's a mistake to say, oh, it's taking away energy from gender persecution, because I'm not sure that those of us who are working on gender apartheid would necessarily therefore take all that time and energy and put it into gender persecution anyway. So I think there's a lot of kind of false dichotomies that are inherent in the question, that there's no more competition between gender apartheid, gender persecution than there would be, for example, between rape and torture, or between even apartheid and a race persecution on the grounds of race, which has existed in international criminal law since the Rome Statute has come into being, without anyone ever saying, hold on, why do you need the crime of apartheid? You have the crime of persecution on the grounds of race. And so for me, when I hear this question, actually what I hear, and I know this is not what Lorraine is saying, Lorraine is stirring the pot a little bit, and it is an interesting question, and it's obviously a question that people have. But what I hear is, when it comes to crimes that disproportionately affect marginalized communities, and particularly are perceived to disproportionately affect women and girls, there's this idea of, oh, you have your crimes, why do you need more crimes, right? This is the conversation that there was when it came to torture and rape. They're like, well, do you need the crime of rape? You can have the crime of torture. But actually what happened was, then it doesn't get properly investigated, it doesn't get properly indicted. So you have, when you have new crimes coming up, new crimes come to the fore really in two situations. One, there's an element of the actual harm that is not captured by the crime. And that would be, for example, the crime of murder and the crime of extermination, which are essentially the same crime, but the element of mass and large scale isn't captured by the crime of murder. So you have both crimes. The other would be, there's an element of the intent which is not being criminalized. And that, I think you can look to the crime of genocide. In truth, you don't really need the crime of genocide. A lot of the underlying acts of genocide, whether it's murder, torture, rape, they're already criminalized. The reason that we have the crime of genocide is because we reckon that there is an intent which is defining, which is driving the crime, which forms the heart of the crime, that is not criminalized in international law. And by only addressing the acts through existing crimes, you are really failing to understand why that crime is being committed, what the aim of the crime is, and what the perpetrators are trying to do, and the true harm that's being affected against the victim community. The crime of apartheid, with a race or gender based, is one of the very few crimes in international criminal law that has a specific intent. I think there are three crimes: genocide, forced pregnancy, and apartheid. And the intent to maintain institutionalized regime of systematic oppression and domination is an intent which needs to be understood better. It needs to be criminalized, certainly, but in criminalizing it, we also embark on a process which says, how do we prevent that? How does that intent come into being? How do you get, for example, from anti-Semitism to the Holocaust, right? That is a line, a red line through history that you don't understand how it happens if you don't criminalize the intent through the crime of genocide. It's the same for the crime of apartheid. How do you move from everyday racism, everyday misogyny? How does that travel throughout time, throughout human action into an intent which is criminalized? And so it takes nothing away from gender persecution, which is an incredibly important crime, but it doesn't cover the facets of the harm and the intent that apartheid does, whether you're talking persecution on multiple grounds or apartheid on multiple grounds. So this is, I think, why there is this idea of saying, like, we need to recognize this crime, because you cannot prevent and punish this crime if you do not recognize and understand what it is. And of course, as Evelina mentioned, you know, if survivors and victims have been using this term, this phrasing for decades, if even in the Southern African experience, Black feminists, anti-apartheid activists were continuing to stress the gender dimensions and went unheard. If you have Afghan women from the 1990s, maybe Iranian women as well, even earlier, using that framing, part of this is such, we can't pay homage and continual reference to survivor-centered justice and then go, oh, yes, survivor-centered justice, but let us intervene and decide kind of what crimes, you know, not listen to them when they're saying this is the harm that's being done to them, this is the harm they want criminalized. So I think those are really important ways of saying, when it comes to gender and persecution and gender apartheid, they're different, they're equally important. I agree that gender apartheid is not part of the discussion around the Rome Statute crimes. It doesn't reduce its importance. And again, it is already an understanding of the differences between the crimes that is already recognized in international criminal law in the crime of apartheid and the crime of persecution on the grounds of race. So if it's not troubled anyone now, then I would question why it troubles people so much, just when it's in reference to gender.
Can I just respond to Sarita? And thank you so much for adding to that. But you know I'm a pot stirrer. You've known me long enough to know that. So I'm going to ask you, in your discussion, in some of the submissions you've made to, for example, around the Crime Against Humanity Convention, do you hear any of this as feedback? I wanted to hear from Evelyn as well around her discussions with parliamentarians. So, for example, what are some of the principled objections that you get back? Because what I'm trying to get at, we're having a discussion around principles here, and to give those of us who are practicing, who are on the ground, maybe working with others, who may have one-off conversations with parliamentarians, with policymakers, and so on, the kind of language that we need to respond in the way you responded. And I mean, I fully agree with you, but have you heard any of those, any of what you just said, any of some of these issues as the kind of feedback in your discussions, in meetings, in presentations around the Crime Against Humanity Convention or in other contexts, so that we kind of know in our advocacy what to address and how?
I mean, I'm happy. Maybe Akila might also want to jump in here because she does more of the discussion with states, as does Azada, who I know has gone to sleep. I would say my experience that those operating at state levels don't necessarily have a really great grip on international criminal law, and so the conversation is much happens more on a political level. I think there is still this view of, you know, oh, you want more crimes. Why do we need more crimes? Why can't we just use the crimes that we have? And I think there is, a kind of gendered undercurrent to this idea of why do these women keep showing up in my office asking for things, which we do. So I think there's that. I do think there's also this idea that maybe some crimes are monuments rather than actual crimes. So, you know, I think it took a really long time to think of genocide as not being a monument to the Holocaust. And for it to be, you know, investigated and indicted, I don't think there was a gap of several decades. So I think there's still this kind of feeling like, oh, well, maybe apartheid should be kind of encased in amber and put as a kind of a monument to the successes of the anti-apartheid activists from the Southern African experience. So I think trying to transit over, and then you have other kind of broader concerns about, oh, but this could work against states that we're friends with. How is it going to work? And then I would say finally, there's obviously sometimes spoken, mostly unspoken, the question of Israel-Palestine in the room and in every room. I don't personally think it has anything to do with gender apartheid, since it would be captured by the existing crime of apartheid and not really linked into gender apartheid, but it obviously is, I think, affecting people's willingness to have a discussion about apartheid writ large. But I don't know if Akila wants to step in with any. She's been doing more of the discussions with states, and so might have more up-to-date impressions.
And we see Akila raised her hand, so please, Akila, go ahead.
Thank you, and I'll try to be brief. I know we're over time. So just maybe a couple of notes to add to Sarita's. I think the first thing is, at least in the conversations with states around the treaty, the first thing that I often get back, particularly from the friendly states, the states that we rely on to actually be the ones who, raise these issues and push forward, is more generally that there's a backlash on gender. And so really the fears around anything new on gender are pushing the boundaries, right? And I will note that this effort around gender apartheid and the Crimes Against Humanity Treaty is tied in with a broader feminist effort around a range of crimes that we see that were not, in the copy over of the draft articles from the Rome Statute that we see as not being adequate, right? So thinking about the fix on the definition of forced pregnancy, and I know Rose is also here thinking about expanding the provisions around reproductive violence, which we, think that were not appropriately captured perhaps within the context of the Rome Statute and could be better clarified. And so the first piece is really about the idea that it's not the moment to be brave on gender. And I think that's something that for all of us who work in this space that we must reject, right? Because that means that it's about the question of the gender definition. It's about the idea that the best that we can do in this moment and that the best that we can ask of states is to try to protect what we have rather than continue to push forward. And so to me, it's not, Lorraine, to your question of, I don't know if that's a principled response, but I think it's the response that I get that's kind of surrounded in a concept of practicality and pragmatism. But I do think that it's inherently just fear-based, right? Because I actually find that across all of the different places where I work in multilateral negotiations, this fear around gender is because actually we don't see those who support gender as actually setting firm red lines around gender. What we see is they let the antis win because they say, well, we're not going to push this forward if you don't agree to XYZ concessions. And we don't actually see the states that say that they are gender champions drawing a red line and saying, well, we are actually going to put, we are now not going to do something if you don't do XYZ. So I think it's really wrapped up, first of all, in this moment where we are stuck in a conversation on backlashes on gender that's preventing us from moving forward in advocacy in particular. I think, courts you can take different strategies. So that's one piece. The other piece, I do think from Sarita's point of view that she was sharing, I think some of it is just kind of like, well, it's really going to be a pain for us to do this. So aren't you happy enough with gender persecution, right? Isn't that enough? We do get that question quite a bit. What is there? And I think Sarita answered that question quite well in terms of what it is. So those are usually the two major areas of pushback. The third one that we get again, and I think there's pretty easy answers to this is, why are you talking about creating a new crime if it's really about one situation, right? We often know that new crimes have come into being as a response to a situation that helps us put a name, a framework to something that happens, right? And so, in this context, again, this is about women in Afghanistan. I think there's a lot of fear, particularly around gender apartheid, because there's so much gender discrimination in every society, that there's also this idea that this could then apply to a much broader set of countries that have different types of restrictions on gender. And so trying to be very clear about, while not precluding any particular situation, trying to be very clear about the legal elements that we are talking about as to why it is that a particular type of systematic domination and oppression that isn't just gender discrimination, that doesn't just, that may have many of the characteristics of gender persecution or the same underlying acts, is not the same thing. So those are some of the main ones that we're hearing, and I hope that was clear.
Yes, it's very clear. And thank you so much for the contribution. And unfortunately, we have to wrap up, although we can continue for long. Many thanks again to all our speakers and participants. The insights that you shared today will directly inform our submission on the development of the gender persecution principles. And as a reminder to everyone who's interested to make their own submission, the submissions are due by November 22nd to the ICC Office of the Prosecutor. But today's insights will similarly inform our collective efforts, I hope, towards a more robust response to these crimes. And I encourage you to all to stay engaged and continue contributing to this vital work. Thank you, everyone. My colleague Angelica is asking me whether you would join us for a group picture. And to our online participant, thank you so much. We'll close the meeting soon. Thank you.